morning, Ms. Murphy.
Good morning.
I think you appeared as a witness in the trial of the case, is that right?
Yes, sir.
And since you were a witness, you were not able to be in the courtroom when the evidence was being presented, is that right?
Yes, sir.
Were you ever able to hear the 2-hour or so interview that RaDonda Vaught had given to Special Agent Ramona Smith with the TBI?
I've heard bits and pieces, not the whole thing.
In the bits and pieces that you heard, did you hear RaDonda Vaught being very emotional and regretful and remorseful for her mistake?
I heard bits and pieces of it, but her talking to the TBI has nothing with standing on the media in front of the News Channel 5 and not saying it to the public and everybody for an apology to the family.
I understand. Thank you.
TBI agent Ramona Smith. Good morning, Agent Smith. Will you please state and spell your name for the record?
My name is Ramona Smith, RaMonaSmith.
And Agent Smith, you are the TBI agent who investigated the particular case that we're here on for sentencing. Is that accurate?
Yes, ma'am, I did.
And you testified in this trial previously. Now, this court has heard all of the testimony since Your Honor presided over the proceedings. So I want to specifically talk about a separate incident with respect to Ms. Vaught. So I want to direct your attention to August of 2020. Do you recall an incident that you were notified about involving the defendant today, RaDonda Vaught?
Yes, ma'am, I do.
Okay. And can you tell the court a little bit about how you became involved with that?
Our general counsel contacted me, Jean Broadwell, contacted me regarding a matter to see if RaDonda Vaught was still under indictment or if that situation had been resolved. And I asked her why, and she said that there was an attempt to purchase firearms at a local store in Gallatin, and they had to deny it, but they had to confirm that she was still under indictment.
Now, let me stop you for just a moment. Do you recall when Ms. Vaught was indicted in this particular case, 2019 A76?
Of February
of
2019. I believe it was like January, February, I don't remember the exact date. She was arrested on February 4th.
Now, based upon the information that you were provided, were you actually assigned by the Tennessee Bureau of Investigation to investigate this particular incident?
I was.
Okay. And can you tell the court a little bit about how your investigation proceeded?
Based on the information I was provided, I went to the gun store in Gallatin and reached out to the individual, spoke with the individual, Nathan Gregory, who conducted the business with Ms. Vaught that day when she came into the store. In talking with him, she had come in and filled out the federal form, which is required for purchasing any firearms, any type of equipment, any type of pieces. He showed me the form where she had filled it out and signed it, and that she was denied, and he submitted her denial form. And then
let me stop you if I can right there. What is submitted a denial form mean?
So when you go in to purchase a gun or any type of part for a gun, you have a background check done through the Tennessee InstaCheck system, which is the Tennessee Bureau of Investigation. We manage that. It goes through the system, and they check you for a background of criminal histories, indictments, things along those lines. And the TBI then sends a denial if there's anything they find as part of that background that would prevent them from purchasing a firearm. They then send the denial form back to the store. He does not know why it's denied. All he knows is that it's been denied.
Now, is there a way to appeal that denial?
There is, and he informed her of the denial, and it's almost instantaneous. That's why it's called Tennessee Instant Check, because it's done quickly. And so he told her it was denied, so she filled out a denial form, appeal form, and that is sent back to the Bureau. And then that takes a little more time, because then they have to go through the process of reviewing it.
Okay. Now, do you happen to have a copy of the firearms transaction record that was filled out that particular day in August?
I do. I left it in my seat, but I do have a copy of it. Yes,
May I
ma'am.
approach, Your Honor? Agent Smith, I want to direct your attention to number 11 on page 1 of 6. If you look at section A, lowercase a, can you read that line?
The entire thing, or just the first part?
Just the first part.
Are you the actual transferee buyer of the firearm listed on the form?
And what did Ms. Vaught check?
Yes.
Now, let me direct your attention to section B, right underneath. Could you please read that line?
Are you under indictment or information in any court for a felony or any other crimes for which the judge could imprison you for more than 1 year?
And what did Ms. Vaught check there?
No.
Now, I want to direct your attention to page 2 at the very top. And if you could go down to maybe the middle of the paragraph where it says, I also understand that making, and if you could read that line.
I also understand that making any false oral or written statement or exhibiting any false or misrepresented identification with respect to this transaction is a crime punishable as a felony under federal law and may also violate state or local laws.
Now, Agent Smith, could you tell the court who signed that document and what the date?
RaDonda Vaught on August 27th of 2020.
Your Honor, if we can make this state's exhibit number 2.
And it is exhibit 2.
Now, Agent Smith, based upon your investigation into this particular matter, was Ms. Vaught charged?
Yes, she was.
May I approach, Your Honor?
You may.
Agent Smith, do you recognize that document?
I do.
Okay, what is that?
It's an affidavit of complaint for taking out a warrant for the arrest of an individual.
Okay, and what warrant? Whose name is listed on that warrant?
RaDonda Vaught,
Okay, and in what county was that?
Sumner.
Okay, and what was Ms. Vaught charged with at that time?
She was charged. Let me read through here. I'm sorry, hold on just a second. Perjury, I apologize. A perjury of TCA 3916-702.
Your Honor, that, I believe, is a certified copy. If we could admit that as the state's next exhibit.
And it is exhibit 3.
Now, Agent Smith, upon following up, did you have the opportunity to speak with the owner of the Blue Line gun store? Okay.
Yes.
And what did he tell you about his interaction with Ms. Vaught that day?
Well, she came in, filled out the form, did the appeal, and then left. And then later that afternoon, she called in and said to him, oh, I think I have this court thing going on in Davidson County. That may be why they declined it, or they denied it.
This court thing?
Mm-hmm. Yes, ma'am.
Now, Agent Smith, were you present in the courtroom during the testimony of Charlene Murphey? Today?
Today, yes.
And did you hear Mr. Stryan ask Ms. Murphy a question about Ms. Vaught being remorseful in her interview with you?
I did.
Okay. And I want to ask you, since you were the agent that conducted the interview, what is your interpretation of the way Ms. Vaught was acting when she did become upset?
In the course of an interview with an individual, you develop rapport with that individual. It means you have to empathize with them at times in their situation and what they've done, and help them to understand that to get that off your chest is soul-saving, if you will. And she was very forthcoming, but she didn't seem shook by it until she found out that they were both from Bethpage. Her remorse during the case was of the attitude, in my opinion, as an investigator, that she felt by telling the truth it would all go away, and that she should be rewarded for being honest. And I appreciate honesty. Honesty is an amazing thing. I don't find a lot of it in my line of work. But it doesn't take away accountability. And I don't think that she feels she should be accountable. She feels someone else should be accountable. I think she was remorseful more for the fact that she knew this was going to go badly in the criminal aspect, in the sense that it wasn't just administrative anymore. It became a criminal issue. And anytime anyone is charged with a criminal issue, they do tend to panic internally. That's just what they do, because they know there's a potential for jail time, and no one wants their freedoms taken away.
I want to direct your attention. Were you present every day or most of the time when you could be in the courtroom for the trial on this matter?
I was.
And were you present after final arguments in this case?
I was.
Your Honor, at this time, we would like to play a snippet of an interview, and then I'll certainly ask Agent Smith who is identified within that.
It's very obvious by the district attorney's actions, the assistant DAs that are prosecuting this case.
Agent Smith, do you know who is giving an interview in this case?
That is Ms. Vaught.
Okay, and you see Ms. Vaught in the courtroom today?
I do.
It's very obvious by the district attorney's actions, the assistant DAs that are prosecuting this case, all three of them in their lives. It is very obvious. They don't know shit about healthcare. They don't give a fuck about nurses. I don't care what Chad Jackson says.
Agent Smith, do you recall when this interview took place, at what point in time during the trial proceedings?
Yes, ma'am. It was between closing arguments and the verdict.
No further questions, please. Your Honor, if we could introduce this particular snippet.
You have it on a flash
Yes, Your
drive?
Honor.
All right, you'll be admitted as Exhibit 4.
Good morning, Special Agent Smith.
Good morning.
I'd like to talk about the Blue Line gun store incident first. TBI was the lead investigative agency on the Charlene Murphey case, is that right?
Yes, sir.
And I think you arrested RaDonda Vaught on the indictment, on the arrest warrant that was issued as a result of the indictment on February the 4th of 2019, is that right?
Yes, sir.
And I believe the event at the Blue Line gun store happened on August the 20th of 2020, is that right?
It was August 27th of 2020, yes, sir.
And then about a year later, August 18th of 2021, is when the General Sessions warrant was issued in Sumner County, is that right?
Yes, sir.
One of your colleagues went up to Sumner County and secured that arrest warrant, is that right?
Yes, sir.
So there was an entire year between the event and the decision by TBI to seek charges in this case, is that right, or in the Sumner County case?
It takes time to develop and investigate a case, yes, sir.
Did you investigate the case, or did your colleague, Colleen Dean?
I investigated this case.
Okay. And you said that you interviewed a young man that worked at Blue Line Gun Store, is that right?
Yes, sir.
Was that Randy Gregory?
Nathan Gregory.
Nathan Gregory.
Yes, sir.
And I think you were asked a question about interviewing the owner of the gun store. You didn't really interview the owner, you interviewed Nathan Gregory, is that right?
I interviewed Nathan Gregory. I did discuss it with the owner who was there. He's Nathan Gregory's father.
And I'm sure the owner told you it's a father-son of customers at the gun store, is that right?
Yes, sir.
And I think they had at least a 3-year relationship when this came up.
I don't know that. No, sir.
When you interviewed Nathan Gregory, did he tell you that it was pretty common for that instant check to come back denied?
I don't know about common. I know it does happen, yes.
And I think he told you, consistent with your testimony, that later that same day, maybe within hours of the event, Ms. Vaught called the gun store and said, I think I know. That is the Bureau of Alcohol, Tobacco, and Firearms, a federal agency's firearm transaction record. Is that right?
Yes, sir.
And these alleged false statements on a ATF 4473 form are typically investigated by the Bureau of Alcohol, Tobacco, and Firearms. Is that right?
We can work in conjunction with them, yes, sir.
And how many of these ATF 4473 cases have you personally investigated before this one?
This was my first.
Now, you were shown State's Exhibit 2, and according to the Sumner County affidavit in support of the warrant, you're focused on question B, is that right?
Yes, sir.
And I think it's 11B for the record, is that right?
Yes, sir.
And let me read this, and you tell me if I'm reading it. Are you, and the you would be the person who's seeking eligibility to purchase a firearm, is that right?
Correct.
Are you under indictment or information in any court for a felony or any other crime for which the judge could imprison you for more than 1 year? Is that
That is exactly what it says, yes, sir.
And it was TBI's insistence that there was a willful false statement made in this application that was presented to the court. Is that right?
It's straightforward. It's 2 boxes, yes or no, and she marked no.
And it's fair to say this case has been pending a long time, is that right?
It's been active a long time, yes, sir.
And there were obviously some discussions along the way as to whether this case could be settled in some way. Is that a fair characterization?
There were several discussions along the way, yes, sir.
Okay. And I'm sure that the district attorney's office kept you aware of those discussions.
Very much so, yes.
And there were even discussions about whether it could be settled maybe on a probationary sentence. Is that right?
I'm going to object to this line of questioning. I don't know that that's pertinent to these proceedings or even to the trial proceedings about any settlement measures.
Overruled, cross-examination.
I'm not trying to get into the settlement. I'm just trying to focus on which the judge could imprison you for more than 1 year. That's one of the elements of the question that's put to the purchaser, the prospective purchaser of a firearm. Is that right?
It is one of the elements of the question. However, another element of that question states very clearly, are you under indictment or information in any court for a felony? And she was very well aware she was under indictment and been arrested for 2 felonies.
And then in the disjunctive it says, or any other crime for which the judge could imprison you for more than 1 year. Is that right?
By felony, the definition is more than 1 year in prison.
Well, you know that, and I know that, and the judge knows that, and the prosecutors know that.
But anyone that is being charged with a crime and has met with an attorney such as yourself is very well aware of what a felony is about and how long they could be sentenced to court, or to prison. It's very well aware and it's commonly discussed between a defense attorney and their client, as you would know.
Right. Now, this was said before Judge Michael Carter of the Sumner County General Sessions Court on May 4th of this year. Is that right?
Yes, sir.
And Ms. Vaught and I were there in court. We didn't see you there that day.
May 4th. I was not there. I had other obligations, yes, sir.
So did you have an opportunity to talk to District Attorney General Ray Whitley or the assistant that was covering the case that day?
I have
Christopher
spoken
Boyano?
with General Boyano, yes, sir.
And there was really no need for you to come to Sumner County that day, is that right?
There was no need for us to come to Sumner County because we weren't having any type of a hearing. Agents go to court cases whether they're required to or not if they are available to keep up to speed.
But I would like to think that Assistant District Attorney Christopher Boyano or the District Attorney Ray Whitley would have had the courtesy to tell you that they were not going to prosecute this case.
They would have if that was the case.
Okay.
But in the discussion I had with Mr. Boyano, that was not the discussion we
Did
had.
Mr. Boyano tell you that they were going to suggest to Judge Carter that the case be taken under advisement for some period of time and then be dismissed?
General Boyano stated they are going to take into consideration the sentencing today and then make a decision if that's the way they are going to proceed. There was no definitives in any of it.
In your mind, it was not definitive?
No, sir. And I clarified that with General Boyano yesterday.
He told you that it's not going to be taken under advisement and dismissed?
No, sir. He said it is going to be taken under advisement what the sentence is today, and it is a possibility that it will be monitored for a year and then dismissed. But it was not said flat out that that was what he was going to do. And as a general rule, prosecutors don't settle cases unless they reach out to the agent to make sure everyone's on the same page.
Well, did you have a discussion with them before May the 4th?
I'd spoken with him several times.
Because you didn't appear on May the 4th, because there was nothing that was going to happen that day.
There was, like I said, I had other commitments that day.
You talked about your interview of RaDonda Vaught, and that's, so it's clear for the record, it's the interview that was played to the trial jury in this case, is that right?
Yes, sir.
And by my recollection, it was about 2 hours or so.
It was.
And it was a very emotional interview for RaDonda Vaught, is it not?
Depends on how you define very emotional. I didn't find she was very emotional. I could tell it was trying on her, but she was not what I would consider remorsefully.
But you will concede that she was extremely transparent in what she was telling you about the events of this medication error, will you not?
Yes.
In fact, she truthfully disclosed to you how distracted she was that day and other things that were going on that sort of deflected her attention from things that she should have been doing.
Oh, yes. She admitted that she was distracted multiple times over and over and over.
And frankly, those candid admissions to you really made out all the elements of the lesser included offense that the jury convicted her of. Is that right?
Candid admissions? What do you mean by that?
What she told you, what she honestly disclosed to you on that 2-hour recording, basically was criminally negligent homicide.
That's what the jury found, yes.
And you told the judge that one of your interview techniques is to make sure that you try to understand the subject and maybe even empathize with the subject. Is that right?
Yes, sir.
And do you remember at the conclusion of that interview that you were very empathetic with RaDonda Vaught?
I was very empathetic with her, and I appreciated her forthcoming, and I shared that with the Attorney Generals. But that doesn't circumvent the seriousness of the amount of errors that she did. We all deserve forgiveness.
In fact, you were so empathetic at the end, you were reassuring her, hey, we all make mistakes.
Right, we all make mistakes. I make mistakes. We all make mistakes. However, every day, today, simple mistakes don't cause the death of an innocent individual that was charged to their care.
Those are my questions.
Can we do that? John Black, can you read it? Going next?
That would say.
Shrine? Defense Attorney?
Elizabeth Cassinger.
All right.
to be sure no one has invoked the rule today. Is that right?
That's right.
Please stand here and raise your right hand.
You swear or affirm that the testimony you're about to give will be the truth, so help you God.
Good morning, Nurse Kessinger.
Good morning.
If you could state your name for the court, please.
Elizabeth Kessinger.
And if you could, please keep your voice up. You've got a very soft voice, and this is a big courtroom. If you could spell your last name for the court reporter.
Kessinger.
And Ms. Kessinger, how are you employed?
I'm a nurse at Vanderbilt.
And how long have you worked at Vanderbilt University Medical Center?
14 years in June.
And where have you worked? What part of the hospital?
The neuro ICU.
The neurological intensive care unit?
Yes, sir.
All 14 years you've been in that unit?
Yes, sir.
And do you know the defendant in this case, RaDonda Vaught?
I do.
And if you would, tell the judge how you came to know RaDonda.
I was a nurse there, obviously, when she was hired, and I was her preceptor after she was hired, and then her co-worker after that.
And just so it's clear for the record, it came up at the trial, what is a preceptor?
A preceptor is a nurse that onboards newcoming nurses and trains them in the care of our patient population, policies, procedures of the hospital and the unit in particular.
And did you serve in the role as a preceptor for RaDonda Vaught?
I did.
So you helped train her.
That's correct.
How much experience did she have when she came to the neuro IC unit?
I think she had 2 years, maybe a year or two of experience.
While you were training her, what sort of impression did you have?
Her own as far as learning our patient population, the diagnoses, the treatments, and she was also very attentive with the patients, going in the room and spending not only time doing the care, but just spending quality time with them and reassuring them.
And I believe you worked with RaDonda between 2015 and 2017.
Yes.
Is that right?
Yes.
How would you describe RaDonda Vaught as a person?
I think she's generous and caring, funny, motivated as well. Even as a person outside of the hospital, she's very motivated and resilient.
In that 2 years that you got to observe her work in the neuro ICU unit, did she become in some ways a leader among the nurses on the 6th floor?
She did.
And in what way did she demonstrate that?
It was her patient care. I think that she always went above and beyond with the patients, and I have described her previously as a nurse's nurse, which means if one of us was sick, she would be our choice.
I think it's safe to say that in the neuro ICU unit you have some very challenging patients.
We do.
And describe for the record the type of patients that the neuro ICU nurses deal with on a daily basis.
It depends on which area you're working in. I think it was talked about previously that we have an ICU portion of the unit, and then we have a step-down portion as well. The ICU are very high acuity patients with lots of comorbidities typically.
And let me stop you right there. When you say high acuity patient, what does that mean?
That means that as far as their illness and injury, there are multiple things that are going wrong. It's not just their neurologic injury that affects other systems of the body. So if there is a neurologic injury, that can affect their airway. It can affect other systems in the body. So.
And you mentioned comorbidities. What are comorbidities?
They're illnesses that patients have in addition to the injury that brought them into the hospital, which can obviously complicate the picture.
Can you tell the court a little bit about the culture of the intensive care unit, particularly the neurological intensive care unit?
It's very fast-paced most days. There are just a lot of things going on at any given time. You're not just taking care of your patient. It's kind of a community. We help each other because some of the patients are so sick that it takes a team.
I want to direct your attention back to December 26th of 2017, the date that this error occurred with patient Charlene Murphey. Were you working that day?
I was not.
At the trial, it was established that RaDonda Vaught was functioning as the help-all nurse on the 6th floor of the neuro ICU unit. What is the help-all nurse?
The help-all nurse is typically more experienced staff, and it's a nurse that helps with bedside procedures with physicians, helps the nurses with anything they may need during the day. We also serve as a mentor to all of the nurses, so if there is a knowledge gap, if there is questions that need to be asked by less experienced nurses, they would typically go to the help-all for that.
How does the role of the help-all nurse compare with the bedside nurses that are in the neuro ICU?
The bedside nurses have an in-depth understanding of their patient. They know history, what brought them into the hospital, where they are in the course of their hospital stay, and what to expect for that shift and the shifts coming up. The help-all gets a snapshot of each patient at the beginning of the shift. We have 36 beds, and we will sit in on charge report, and you know the patient's name, their admitting diagnosis, and their acuity is basically what you know.
This may sound like a silly question, but the nurses in the ICU unit, do they have to deal with distractions as part of the job?
Yes, absolutely.
And tell the court a little bit about the typical day in the life of an ICU nurse in terms of the distractions they're trying to filter as they do their job.
Well, first of all, are you asking about the help-all or the bedside nurse?
Well, let's start with the help-all.
Okay. The help-all carries a phone that is connected to all of the nurses, and then that phone is also listed in the computer, so physicians call them, other providers, case management, the charge nurse, and you carry that phone with you all the time and answer the phone when it rings, kind of no matter what's going on. And then we also carry a rapid response phone. We don't anymore. We did when RaDonda was working there. So if there is a rapid response called on one of our floors, we would respond to that as well.
And is the help-all nurse also cast in the role of training throughout his or her shift?
Yes, at times. We will have orientees with us as well.
And if you had an orientee with you as a help-all nurse, how does that factor into the calculus of distractions and things that have to be filtered?
Well, it can be a very big distraction because you're talking through everything that you're doing. And questions, because you're teaching, you're getting asked a lot of questions at the same time.
Have you had a chance to discuss this medication error and the consequences of it with RaDonda Vaught?
Yes, sir.
What can you tell the court about the effect that this has had on RaDonda?
I mean, I think for a significant period of time it broke her.
I'm sorry, can you say that again?
I think for a significant period of time it broke her. It broke her heart. And her heart is still broken in many ways. There's been talk that, you know, she is resilient and she has built a farm, but she still has a broken heart.
Has she expressed to you how she feels about Charlene Murphey and the loss that the Murphey family has endured?
She's devastated and has been ever since. And she has said that she'll never get over it, and she knows that the family has suffered a terrible loss, and she understands what led to that loss.
we are going to be asking the court to consider alternative forms of punishment, specifically probation. If the judge saw fit to place RaDonda Vaught on probation, there would be numerous conditions that she would have to abide by. You've known RaDonda for how long at this point?
6 years.
Knowing her the way that you know her, do you think that she could abide by all the conditions of probation?
Yes, I do.
Those are my questions.
Go ahead, Your Honor.
Call Kelly. Stand and raise your right hand.
Do you swear or affirm that the testimony you're about to give will be the truth, so help you God?
Good morning, Ms. Kelly.
Good morning.
If you could state your name for the court, please.
Kelly.
And you're going to need to spell both your first and your last name.
First name Kelley. Last name Kelley.
And where do you live, Ms. Kelly?
I live in Andalusia, Alabama.
And do you know RaDonda Vaught?
I do.
And explain to Judge Smith how you know RaDonda.
RaDonda and I went to grade school together, so I have known RaDonda for many years. Over 26 years.
And have you remained in contact with RaDonda over those 26 years?
Absolutely.
Now, obviously RaDonda was born in Andalusia, Alabama.
I don't know where she was born. I know she was raised.
She may have been born in the Panhandle, but lived in Andalusia.
Yeah. Yes.
And you all went to school together.
We did.
How would you describe your relationship with RaDonda?
RaDonda's like a sister to me, so very close, like family.
And I believe you have children, is that right?
I do. I have two children.
And does RaDonda have a relationship with your children?
Of course she does. She doesn't have children of her own, but she's like a little mom of mine.
Describe for Judge Smith the RaDonda Vaught that you have known over the past almost 30 years.
RaDonda and I have known each other for, I'm so sorry, but we've known each other for many, many years, and I have seen just about every side of RaDonda that you could possibly know about a person. RaDonda is sweet, she's kind, she's loving, she's caring. She has got the sweetest soul. I call her sometimes whenever I just need a little bit of a pickup. She's always there with a kind word. I love her dearly, and I just appreciate her always being there for me.
There came a point in time when RaDonda told you that she wanted to be a nurse, is that right?
Yes.
What was your reaction when you heard that RaDonda wanted to be a nurse and wanted to go to nursing school?
RaDonda, she'll be great at whatever she does. So when she said that, there wasn't a doubt in my mind that she would be so caring and loving, and she would give her patients the best care like she would if it was, her own family. I mean, she's just so giving, and she doesn't ask for anything in return. She's just a giving person, and I knew that she would treat her patients in that same manner.
And did she possess those caring and loving and giving traits even before she went to nursing school?
Oh, yes, she's been like that since we were little.
You're probably her closest friend, is that right?
We've always been really close. Yes.
And I assume she spoke to you after this event at the Vanderbilt University Medical Center in December of 2017.
She did.
And what effect has all of this had on RaDonda in your estimation?
If tears were words, there would be many. We cried together a lot over this. Sometimes less words are more. We don't have to talk a whole lot about it. I know how she feels. I know the person that she is inside, and so there's no question as to whether or not she's broken about everything that's happened. There's no question about that. I think I know I don't really have to talk to her in depth about every little thing that happened because I don't really know all of that. I do not have a nursing background, so I don't know all the health stuff. But personally, I know that she's dealt with this very hard.
You know that she's lost her nursing license
I do.
and will never practice as a nurse again. What kind of work is she doing now?
She owns a farm.
And do you know roughly how long she and her husband have owned that farm?
Oh, it's been 6 years, 7. I don't really know the exact date, but it's been a while.
You visited the farm before, is that right?
We have.
Big operating farm, is that right?
Yes, we own a farm, and so we go and get tips, take the children out.
And that is her life now, is that
It
correct?
is.
You've heard me ask another witness about probation and whether that witness or you believes that RaDonda could abide by the conditions of probation. Knowing her the way that you know her, do you think that she can do that?
Without a doubt.
Do you think that she's got the mental discipline to follow any instructions of a probation officer or the court?
Yes, I do. She'll be on the farm.
Thank you.
Cross-examination?
No question, Your Honor.
Next
Call
witness.
Becker Ray. Stand here, raise your right hand.
Do you swear or affirm that the testimony you're about to give will be the truth, so help you God? I do.
Good morning, Ms. Ray.
Good morning.
State your name for the court, please.
It's Rebecca Ray, R-A-Y.
Thank you. And where do you live?
I live in Bethpage, Tennessee,
And how long have you lived in Bethpage?
since 2018.
And what brought you to Bethpage, Tennessee?
Road, Old Mount Vernon Road, and her husband and her pulled up and said, it's pretty dangerous to walk a baby on this road within a stroller, and they were concerned, and then they introduced themselves, and we both talked about I was a nurse practitioner, and I explained a little bit about myself, and she told me a little bit about herself, and then we just hit it off from there.
And you all became friends.
We did, yes.
And how close do you live to RaDonda's house?
Just a couple miles, but we live in a big farm community, so that's like next door.
How would you characterize your relationship with RaDonda?
RaDonda and I have really bonded over the last few years. I'm a nurse practitioner, and so my first year as a nurse was in the neuro ICU. I was also in labor and delivery, and I had a lot of different positions as a nurse, so we tended to tell a lot of just stories, bonded over patient stories, and I really realized that she was the kind of nurse I was. She's the kind of person that I would want to take care of me. I'd want her to take care of my family. She just embodies the soul and strength and resilience of a nurse, and I just admire that in her so much, and I just have been so blessed to have her in my life.
I think you were here for every day of the trial, is that right?
I was.
you and your husband were here in support of RaDonda, is that correct?
Yes, we were.
What sort of qualities have you seen in RaDonda over the past few years that you've come to know her?
She is one of the most generous, loving, honest, caring people that I have ever known. And I mean, I don't have a lot of close people in my life, but I consider her one of the closest. I can tell her anything, even through all of this that's happened. Anything that's happening in my life, she's a listening ear. She's, anything, and so she's very special to me and to my family as well.
I think now she's exclusively on her farm, is that right?
That's correct.
You've heard the questions about probation. Do you think that she could abide by conditions of probation?
Absolutely, yes. I think she is an excellent candidate for probation.
Thank you.
Thank you.
No, you're not. Call Caitlin Stokes.
Stand and raise your right hand.
You swear or affirm that the testimony you're about to give will be the truth, so help you God.
Good morning, Ms. Stokes.
Good morning.
If you could state your name for the court, please.
Caitlin Stokes,
And if you could spell your first name for the court, please.
Kaitlyn.
And where do you live now?
I live in Bowling Green, Kentucky.
And how are you currently employed?
I'm a nurse practitioner with Commonwealth Health Corporation in Bowling Green, Kentucky.
And do you know RaDonda Vaught?
Yes.
And explain to Judge Smith how you know RaDonda.
I went to nursing school with RaDonda, so we met in 2012. We became essentially nursing school wives, is what we like to call it, because we were best friends throughout nursing school, finished together. We both worked together at VUMC, and we've remained friends since then. The kind of nurse that I wish I was, because she's the kind that she takes the time with her patients to sit and explain to them things that no one else has. She will paint their nails, she will trim their toenails, she cares about the human experience genuinely and takes the time and effort to show that. She is thorough, she is competent, she is caring, she is, as others have stated, everything that you would want in a nurse.
In terms of her devotion to her patients during the shift, did that ever interfere with her ability to get her charting done within the normal hours?
Yes, she would often stay late. We would call each other and talk to each other at the end of shifts, and she was always over her shift times because she would spend so much time in her patients' rooms that she didn't get the time to sit at the computer where others, may get in, do a task, get out, get to where they can do their charting. She would take so much time to explain things and take so much time to do the right thing that she did not get to do her charting until later in her shift most times.
And you told the court about the extra effort that she put forth with her patients. Do you have any specific recollections about instances that struck you as being unusual?
Yes, there was one patient that was involved in a MVC and sustained a head trauma. She was 16 and she was set to go to a rehab facility. She'd been in the neuro ICU for an unknown amount of time that I'm not aware of, but I know it had been a few days, and in the dynamic, changing atmosphere such as an ICU setting, you don't often have times to do the little things like take out the particles of debris from the trauma that occurred or wipe blood and things like that. And she told me about how this girl being 16, she wanted her to feel good. She wanted her to have the best start that she could going to this rehab facility. And so she took the time to get the remainder of the particles of trauma, the glass, things like that, out of her hair. She wiped the blood. She washed her hair and braided it for her. In true RaDonda fashion, she said, look good, feel good. That she wanted her to
to feel good, even though she was in, this compromised neurological state, to be able to have the best fresh start she could in a rehab facility.
And I don't want to get too personal with you, but did you have a difficult pregnancy and some health issues in 2021?
Yes, so I was admitted to the hospital with some emergency complications when I was 8 months pregnant with my daughter. And I was in the hospital for 10 days. We knew that I was going to stay there until delivery. It had happened in the middle of the night, so I kind of came as I was, didn't have anything. And all I did was let RaDonda know. And the way that RaDonda works is that she is thorough, and she's your person that you want there. And all it took was one phone call, and she showed up with 2 giant bags of every, coloring books, a fire stick, shampoo, personal care essentials, pajamas. She brought my family food. We have a picture of her actually plucking my eyebrows and painting my nails in the hospital. And this is in the middle of when she is having her life crisis and when this is going on. And she said, we're not talking about that. We're here to care about you. And that's what RaDonda does. She cares. She cares.
As a friend and a colleague, did RaDonda talk to you about the Charlene Murphey incident at Vanderbilt University Medical Center?
She did. She called me the same day that it happened. Again, we would speak to each other, usually daily on our commutes. And that day, she called me.
Judge, I'm going to object to your statement. She hasn't offered anything. Okay, I'm just thank you.
Judges, the sentencing hearing, I think the rules of evidence are somewhat relaxed on your side.
I'll call the questions and have all of that.
Let me ask it to you this way. She told you about what happened.
Yes.
And what did you discern regarding the effect that all of this was having on RaDonda?
Yeah. Essentially, she spoke as though, the best way that I know to phrase it is someone that had experienced a trauma, someone that was in a trauma response. She was slow to speak. She was questioning how this happened. She was very tearful. She was concerned for both Miss Murphy as well as what is to come as far as her job and where this would go. I reassured her at that point and told her about a medical error that I made, a medication error that I made, and the outcome of that, and how it was a large error, and how it had a positive impact and a change of culture in the facility, and reassured her that these things happen and that she did all the right things and she did everything she could, and that we would get through this.
And I think you've been a nurse for, about 10 years at this point?
7. Oh, no, just kidding. Graduated 2014, so yeah.
Getting close to that.
Yeah.
In your experience, are medication errors pretty common among nurses?
Yes, absolutely. I have had many medication errors, one of which was very large, and I'm just lucky that the patient outcome was a positive one. I know several people. I don't know anyone who has said to me, I've never made a medication error.
Do all nurses report their medication errors?
No. Nurses are advised to report their medication errors. I mean, we know that it is the right thing to do. We are told, that is how you change a culture, that is how you improve processes, and that is what the culture is. However, it's terrifying whenever you make a mistake like that and you have people's lives in your hands and things. You instantly have that flight or fight response, and you think, oh my gosh, what do I do? And of course, our job as nurses is to care for people, and so we check on the patients and then we report. But I'm sure that there's many nurses that do not do that, especially if there's fear of retribution.
Those are my questions.
You said that you had a very large medication error. Did that result in a patient death?
It did not.
Okay. Why did it not result in a patient death?
I caught it in time, essentially.
How did you catch it?
I went to do the same error twice. I actually had this error it was with insulin. So insulin is a double check medication. You have to have it checked by another nurse. I actually had it checked by 2 nurses because something seemed off. Both nurses gave me the go-ahead, and so I administered the medication. It was based on what the patient ate. So the patient ate more, and I went to redraw more insulin to give him, at which point I realized I was drawing it incorrectly.
How were you drawing it?
I was drawing it in a TB syringe and not an insulin syringe.
Okay. So
Which changed I gave the patient 10 times the amount of insulin they were supposed to have.
And that's something I'm very familiar with. I've been a diabetic for 30 years.
Yeah.
I was 12 years old when I was diagnosed and I had insulin pump therapy.
Yeah.
So were you trying to give the patient fast acting or slow acting or long acting?
I believe it was fast acting. I was in the ER, so sliding scale is not something that we do primarily. It was a situation that I'm not super familiar with, but.
Okay. But how did you realize there was a medication error?
I looked down at the syringe and saw that it said TB written across it, where the first time I had missed it because I was distracted.
Okay. And you said very kindly of you, I think, that Ms. Vaught was a better nurse than you could ever be.
Mm-hmm.
Did you ever commit a federal and state crime just to get a gun by lying on a federal firearms form?
I don't have. Am I allowed to not comment on that?
Oh,
Just answer the question as asked.
Can you repeat the question?
would you,
Yeah.
since you're comparing yourself to Ms. Vaught,
Yeah.
would you lie on a federal firearm form to get a gun, which qualifies as a state and federal crime?
Not knowingly.
That's all I have.
There you go. Call, have one more witness, and then Ms. Wall will have an unsworn allocution. Julie Schaefer.
Do you swear or affirm that the testimony you're about to give will be the truth, so help you God? Thank you.
Good morning, Ms. Schaefer.
Good morning.
If you would spell your last name for the court.
S-H-A-F-F-E-R.
And you are a nurse, is that correct?
I am.
And how long have you been a nurse?
September of 1997.
And do you know RaDonda Vaught?
I do.
And please tell Judge Smith how you came to know RaDonda.
We met in February of 2019 when she came into my department as a new employee.
And how long did she work in your department?
She left in December of 2019 to go into a separate division.
And over the course of knowing RaDonda, did you all become friends?
We did.
And could you describe the type of person that you find RaDonda Vaught to be?
Yeah, she, she walked into our office not knowing, really what the job that she was going to do entailed. And we weren't sure because we hadn't met her before. And what we found was that she was a very quick learner. She was a great addition to our team. She was always willing and open to learn new things with a really cheerful attitude. In the middle of what had to have been a scary circumstance because it was a brand new type of job that she'd never done before.
Did there come a point in time that you and RaDonda talked about the medication error that she made while she was employed?
Yeah, we never really talked great deals of specifics, but we talked a lot in generalizations about what had happened, yes.
And did you form any judgment about the effect that the entire incident had on RaDonda?
Oh, I know that it was very devastating for her. She always expressed regret in regretful tones whenever we were discussing what had happened. I know that the burden of what she had done weighed very heavily on her.
And if my math is correct, you've been a nurse about 25 years at this point?
I have the gray hairs to show that, yes.
Do you have any thoughts about RaDonda's conduct immediately after she realized that she had made that medication error?
I know that she was very open and she was very transparent about what happened. Someone had to come and ask her, you know, what happened with your. That was an important aspect of her character to know.
And I assume that's not a universal response of all nurses immediately.
You know, I've never, I hate to say it's not universal. You know, nobody has ever come up to me and said, well, I did this and I didn't tell somebody immediately. But I do know as a human nature, when you make a large error, that it's not the first thing you want to do is take responsibility for it. I think it's probably easier to talk about it in human nature terms.
We've been talking about a request that we're going to make of Judge Smith about probation. And you've been in the courtroom this morning. Do you also agree that RaDonda Vaught is the kind of person that could abide by the conditions of probation?
I don't have any concerns that she wouldn't be able to.
Thank you.
No question, John.
Thank you.
Your Honor, if it's appropriate at this time, Ms. Vaught will make an unsworn allocution statement.
That'd be fine. If she wants to stand at the podium and make that statement.
Yes, ma'am.
I would like to apologize to Ms. Murphy's family, first of all, and I'm sorry that you haven't heard it from me sooner. Just don't know how to handle this, and I'm sorry that I haven't said it to you sooner. I'm so sorry for what you have lost and for what my actions have caused you to go through. Your mother, your wife, your grandmother, she did not deserve that. And I'm sorry that this very public outpouring for me has been something that has caused you all to continue to live this over and over. You don't deserve that. And I'm sorry. I hope that it has not come across as people forgetting about your loved one. When nurses are upset, they're upset because they want people to take care of people. And I think we're just in the middle of systems that don't understand one another. But no one has forgotten about your loved one. No one has forgotten about Ms. Murphy. And we are all horribly, horribly sorry for what happened. No one more than me, but I'm sorry that you haven't heard that from me before. And I want you to know that I will never, ever forget my role in this. And I don't know what else to say that is going to make anything any different. Saying I'm sorry doesn't seem like enough, but you deserve to hear that, and you deserve to know that I am very sorry for what happened. I wrote a statement, Judge Smith. Words alone will never fully express the remorse and the sorrow for my actions and the horrific loss of Charlene Murphy's life. I am forever and will be haunted by my role in her untimely passing. Numerous times a day I think about her. I have a picture of my grandmother at my house. Every time I see her, I think about Miss Murphy. Every time I see a Vanderbilt logo in Nashville around town, I think about her. I see a person wearing scrubs, and I think about her. I go to check my mail, and I think about her. People walk up to me on the street and offer hugs and condolences, and my first thought is, they're hugging me, but someone else is gone because of that.
is very much alive in my mind and will be. Every day she reminds me of the consequences of my actions. Helping others is a trait that's always come really naturally to me. It's always brought me a lot of joy and fulfillment in my life. And when I became a nurse, caring really genuinely for my patients and their families was just an integral part of my daily life. When they would express gratitude for how I provided care for them, I would tell them I care for people like I would want my grandmother to be taken care of. And on that day, I let her down. I let Charlene Murphey down. I let her family down. I let myself down. I was horrified and completely lost. As I said, there's no book on how you proceed. No one's going to tell you what to do after this, or how to feel, or how to express yourself. So, in my profession, you are trusted to be honest, and that was the only thing that I knew to do, was to just maintain my composure in what has been a really horrible situation and try to do the only thing that I have been educated and trained to do in this aspect, which is to tell the truth. At her bedside, Ms. Murphy's bedside, to her providers, to my charge nurse, to the human educator who was present, to risk management, to my manager, to the associate nursing officer, to the Veritas report that I filled out there that day, giving as much detail as I could about what happened. 8 months later, I was interviewed by the Department of Health, and I spoke with Mary Randolph and provided her with about a 2-hour account of what happened. I never met them again. I had another phone call with an agent from the Department of Health, providing her with answers to what happened. In November, I spoke with another agent, and in December with Ramona Smith of the TBI in her office there at the Medicaid Fraud Division, and I have tried to just maintain a professional composure because I don't know what I'm supposed to do otherwise. So if my statements or lack of what appears to be emotion on the outside came across as unremorseful, I can only say that that was terribly inaccurate. In my life, I have learned to hold things in and deal with it. You keep your composure together until you are able to deal with that separately, and that transfers over into nursing and healthcare. You can't be the person to stand at someone's bedside in the middle of something really awful and chaotic happening and fall apart. You have to learn that you put your emotions and your shame and your remorse aside and you deal with it. You don't put that on other people. You don't bring it into that situation. You deal with it at a later time. And the people that spoke to you today, I think that they expressed that I have dealt with those things privately. I tried my best not to bring those things into my
professional descriptions of what happened here. I just want to make that very clear. After the last interview with Ms. Smith, and I was indicted on charges, I did obtain an attorney, and then again, even with Mr. Striax's advice, I have continued to tell the truth and express every detail, both in retrospect of what happened, so that the information could be used in the best way possible to make changes, to make people aware of what happened and understand how to evaluate this process within healthcare systems so that things like this don't have to happen again. It shouldn't have happened with Charlene Murphy. It did, and we're here now. But hopefully my openness and honestness about my mistakes can help someone to evaluate how to change things for the future of healthcare. From the very moment that I administered this incorrect medication, I have made every attempt to acknowledge responsibility for my actions. I have lost far more than just my nursing license and career. I will never be the same person. When Miss Murphy died, a part of me died with her. And sadly, it was too late to change her outcome when I realized my mistake. But as a nurse, I can think of no other way to honor and respect her than to disclose every detail that led to her harrowing death in an effort to ensure that this might never happen to another patient. And I have replayed my mistakes over and over again. I have certainly fallen from grace. I have experienced anxiety, depression, remorse, sleepless nights. This has been the most horrifying experience of my life, and at the same time, the most humbling experience of my life. It is not an easy task for me to stand here in front of you and in front of Ms. Murphy's family, knowing the death that she suffered, and knowing the 4.5 years that they have suffered since this, and ask for your leniency. At the same time, I can't see any public benefit in a harsh sentence. I have no way of ever recommitting an offense like this. I do not have a nursing license, and I will never be able to practice in patient care again. I will never be able to reoffend. I'm not a threat to public safety. I am concerned for both the people in healthcare and anyone who might, any patient, any person who might become a patient in the healthcare system, that this sentencing is bound to have an effect on how they proceed. Both in reporting medical errors, medication errors, raising concerns if they see something that brought to someone's attention and could potentially have a negative effect on them. And I worry that it's going to have a deep impact on patient safety. And that comes from the point of any nurse, any doctor, anyone who takes care of patients. The last thing that you want to do is cause them any harm. And we want to make sure that we do things in a way that protects them. This is a very difficult, it's a very difficult situation to try to express how I feel and how this affects healthcare and also what is appropriate in the justice system. They operate very differently. I'm just very sorry. I'm very sorry for what happened. It is within your consideration. I humbly ask you to consider everything an appropriate sentence.
Yeah, that's our proof.
Any rebuttal proof in this state?
No rebuttal, Your Honor.
Argument on sentence, please state.
Your Honor, first and foremost, the court's responsibility is to determine the length, manner of sentence. First of all, the state would like to point out that we do believe there is an enhancement factor that applies to this factual scenario. And that enhancement factor would be the defendant abused a position of public or private trust. And quoting from the opinion of State v. Kissinger, 922 Southwest 2D 482, 1996. Factor 15 allows a sentence to be enhanced when the defendant abuses a position of public or private trust. As such, application of this factor requires a finding first that the defendant occupied a position of trust, either public or private. The determination of the existence of a position of trust does not depend on the length or formality of the relationship, but upon the nature of the relationship. Thus, the court should look to see whether the offender formally or informally stood in a relationship to the victim that promoted confidence, reliability, or faith. Your Honor, I submit to you the victim in this case, Charlene Murphey, was a patient at Vanderbilt Medical Center. When RaDonda Vaught, the defendant in this case, was asked to administer this medication, she became in charge of this patient. She therefore began a relationship with this patient, a practitioner-patient relationship.
Let me ask you a question about the application of that enhancement factor, General. The language of the factor that the defendant abused a position of public or private trust suggests to me that there is some sort of intentional or deliberate mental state that would be required for that factor to apply. Are there any cases in which this factor has been applied where the mental state of the offense is more of a criminally negligent or something, where there's been a mistake of this nature? And obviously, we don't have cases just like this.
Right, Your Honor, and specifically, I think in this, and I'll go down a little bit further, and let me just finish this portion of it. If the evidence supports that finding, that there was a relationship, and that relationship promoted confidence, reliability, and faith, I don't think there's any question as to this patient-practitioner relationship based upon the victim when she relied upon a practitioner, a nurse, to give her the best care. Then it says that if the evidence supports that finding, Then the court must determine whether the position occupied was abused by the commission of the offense. And possibly this particular enhancement factor may apply more to the gross neglect of the patient, where.
So can't you believe it is applicable to count one?
More specifically, Your Honor makes a good point on that, but the application of that intent would be the knowing standard, and she made a knowing choice to walk away from the patient knowing that she had to provide that care and monitor that patient. And so I think based upon the analysis by this court, the court must determine whether that position occupied was abused by commission of the offense. And I think it's very clear that when she made that knowing choice not to stay with that patient and not to monitor that patient, that she abused her position.
She's in the case named Kissinger?
Yes, Your Honor. And that particular language is on page 8 of the opinion. Your Honor, I'd like to jump over. I know Mr. Stryan submitted a sentencing memorandum to the court, and having one day, we submitted a brief response to that memorandum. But I think what is very important to note, Mr. Stryan talks about the ability of the defendant to receive 4035-313, judicial diversion. And specifically within the 4035-313 statute, now the conviction in this case, as it pertains to count 1, impaired adult abuse or gross neglect of an impaired adult, 71(6), 117 and 119 were applicable back in that time. And that would have been under the welfare code. Specifically in looking at 4035-313, the effective dates of July 1 of 2017 to July 30th of 2018. As used in this subsection, a qualified defendant means a defendant who, jumping down to subsection C, is not seeking deferral of further proceedings for a sexual offense, a violation of 3915-502, which is exploitation of a vulnerable or elder adult, 71-6-117, which would be abuse or neglect, or 71-6-119, gross neglect, as this was the conviction of the charge that the defendant was found guilty of. This particular conviction is precluded from any deferral under 4035-313. Furthermore, looking at the statute effective from July 1st, 2017 to December 31st of 2018, specific knowing abuse, neglect, or exploitation, TCA 71-6-117, it also encompasses 71-6-119, which would be the higher charge of gross neglect. Following a conviction for a violation of this section, or section 71-6-119, as was the verdict in this case, the clerk of the court shall notify the Department of Health of the conviction by sending a copy of the judgment in the manner set forth in TCA 6811-1003 for inclusion pursuant to Title 68, Chapter 11, Part 10. Upon receipt of the judgment of conviction, the department shall place the person or persons convicted on the registry of persons who have abused, neglected, or misappropriated the property of a vulnerable adult. So, meaning, upon conviction for 71-6-119, the defendant automatically is permanently placed on the Tennessee Adult Abuse Registry. In addition to any other punishment that may be imposed for a violation of this section, if as determined by the court, the victim was 60 years of age or older, then the court shall impose a fine in an amount between $50 and $200. The additional fine shall be paid to the clerk of court imposing the sentence, who shall transfer it to the state treasurer, who shall credit the fine to the general fund. So, Your Honor, those are conditions that are placed upon the defendant's sentence specific to a conviction for 71-6-119, also precluding her from obtaining 4035-313 as to count 1. Furthermore, Your Honor, technically the defendant could be eligible for 4035-313 judicial diversion as it pertains to count 2, criminally negligent homicide. I'm reading from an unreported case, State versus Profit, that also cites a reported case, State versus Cutshall, 967 Southwest 2D 332. In determining whether the court should grant judicial diversion, the court could also take into the same factors as pretrial diversion. And it goes through a list, several I think are very important to this case. A court should consider the defendant's criminal record, social history, mental and physical condition, attitude, behavior since arrest, emotional stability, past employment, home environment, marital stability, family responsibility, general reputation, and amenability to correction. Talking a little bit about attitude, this court heard the recording that was played in the state's proof, a snippet of an interview that was given by Ms. Vaught in this case where she uses curse language to a reporter about the actions of the District Attorney Generals in prosecuting this case. And certainly this court is well aware that we have a job, we are assigned to do our job. It's nothing personal, prosecuting a case as with any case in Davidson County. So I think the court should take that into consideration.
Aren't the factors that the court considers on judicial diversion set out in the State versus Electric Plain?
Yes, Your Honor, but these factors are also laid out in more detail here in State versus Cutshall, and it's mentioned in State versus Profit. This particular case deals with a nurse who committed willful exploitation, neglect, or abuse.
Electric Plain doesn't mention attitude.
Your Honor, I think this is a more detailed list. Certainly it says, and I'll read from the top of that, once a defendant is deemed eligible for judicial diversion, the trial court must consider several factors when deciding whether to grant judicial diversion. Due to the similarities between pretrial diversion, which is administered by the District Attorney General, and judicial diversion, courts draw heavily from pretrial diversion law and examine the same factors. And then it does go through those factors as laid out in the Cutshall case. And so I think the court necessarily, even as raised here in this opinion, I think the court can look to other factors, even so, involving the defendant's behavior or attributes to the defendant, especially while she is on bond. In this particular case, behavior since arrest. The defendant picked up a new criminal charge, has engaged in criminal conduct while on bond, specifically providing false information on a federal form. And the court certainly has that form to review prior to making its determination, but it's obvious that the defendant did not provide correct information and therefore was charged. Certainly, the defendant's lack of criminal record obviously does play in her favor here, and the general reputation from members of the community who have come and testified for her. And I think the court has a balancing test there, but I think the state's position here would be that the court do take into consideration Ms. Vaught's actions prior to sentencing by this court, her actions in the media as well as her actions in committing other crimes. I do believe Mr. Jackson would like to give a brief response following Mr. Cheyenne.
Let me ask you before you sit down, John, because I didn't hear you address the application of an enhancement factor and the question of diversion, but talk to me a little bit about whether Ms. Vaught is a favorable candidate for probation.
Your Honor, based upon the law, being convicted of a Class C felony, being convicted of a Class E felony, she does pose to be a favorable candidate to probation. Of course, the court obviously takes into a balancing test there based upon her actions actions, whether she appreciates the nature of this charge, of this conviction. So the court has a balancing test as well, based upon her conduct, to make that determination. But as far as the law is concerned, with her convictions for Class C and Class E felony, she is an applicable candidate.
So she is statutorily eligible, having been convicted of a Class C and a Class E felony, there being no evidence to the contrary. Does the state see any evidence to the contrary that would make her an unfavorable candidate for probation?
No, Your Honor.
Okay.
The state's position, as Your Honor can see, is we don't believe that, well, obviously she's precluded from diversion as to count one. She will not be able to get 40, 35, 313, but the state's position is that the court needs to weigh very heavily on the defendant's conduct and attitude.
With respect to the diversion
With
of
respect
count
to
two?
Yes, Your Honor.
Okay. Mr. Stryance?
Thank you, Your Honor. And I will address the eligibility for diversion a little bit later in the comments that I made to the court. Your Honor, I did file a sentencing memorandum with the court. I wanted just to highlight a few things that I thought were very significant to the court's determination. I thought it was significant that Dr. Roy Neely of the Vanderbilt University Medical Center from the Neuro ICU unit sent an unsolicited letter to the court. I received a copy of it and made it part of the 40 character letters that were filed with my sentencing memorandum. Not anything that I spoke to Dr. Neely about, not anything that I solicited. And I think from the letters that you've seen, by all accounts, RaDonda Vaught was an excellent, compassionate, caring nurse. She was obviously very well respected among the doctors, among her nursing peers. Vanderbilt University Medical Center even trusted her to function as Ms. Kessinger had functioned in the role of a preceptor, training new employees. One thing that I wanted to highlight from Dr. Neely's letter, he found her to be a thoughtful and caring nurse. I'm reading from a passage of his letter. And what was notable to Dr. Neely was the consistent high level of attention he saw her provide to so many of the BUMC patients and their families when they worked together in the Neuro ICU unit. He found her to be very conscientious, that she cared for patients in a very competent way. And he emphasized that she was not, quote, an average nurse. And he expressed general concerns about penalizing nurses for medication errors and the chilling effect that would have on nurses reporting errors. Some of RaDonda Vaught's nursing colleagues, I think, had some very poignant things to say about RaDonda and her work at Vanderbilt. A nurse by the name of Alexandra Shero, S-H-E-R-O, for the court reporter, wrote a very extensive letter. And just a few highlights from that. She expressed what an honor it was to work with RaDonda Vaught, how much she had learned from RaDonda Vaught, what a clear leader on the 6th floor RaDonda Vaught was among peers and providers, that she was the type of nurse, if anyone had any questions, concerns on the 6th floor, she was the go-to person. And the theme that you've heard from a lot of the witnesses this morning is the over and above and beyond that RaDonda Vaught would go to spend personal time with her patients. Ms. Shero also noted what was going on at the hospital on December 26, 2017, the day that this happened. She characterized it as one of the busiest mornings that she had ever experienced. Even though it was the holidays, they were very full, had many ill patients according to Nurse Shero, many of whom needed imaging, needed to be taken from the 6th floor down to the 1st floor. as you know from the proof in the case, Nurse Vaught was the health hall nurse, and she had an orientee with her that day. So there were a lot of things going on for Nurse Vaught in that role as a health hall nurse on that day. And it was interesting that Nurse Shiro talked about midazolam, talked about Versed, and also talked about vecuronium, and that in her experience, the fact that the vecuronium had to be reconstituted, and she put this in italics in her letter, was not a red flag to her, given the medications that they were constantly being bombarded with and how many medications needed to be reconstituted. And also, she noted what came out of the trial, that Vanderbilt University Medical Center had recently changed their pharmacy dispensing system. So the letters are clear from her peers that she was an excellent nurse, somebody that could be looked to. I also made an argument in the sentencing memorandum that in addition to her extraordinary acceptance of responsibility, that's my characterization, talking to the people, the doctors at Vanderbilt, when they were literally at bedside in Miss Murphy's room back on the 6th floor, figuratively scratching their heads, trying to figure out, well, what's going on with Charlene Murphy. Once RaDonda Vaught was handed that plastic bag that had the wrong medication in it, she walked right into Charlene Murphy's room and told those doctors exactly what the problem was. And what followed, she went to an office and put together a Veritas report. The court may remember that term from the trial. That was supposed to be a confidential report that nurses and providers were to put together, where they report anything that they see at the hospital that they feel is not exactly right. And RaDonda did that. And what followed from that was a series of interviews. And whether it was the Vanderbilt University Medical Center, risk management people, to the Tennessee Department of Health, to the Tennessee Bureau of Investigation, and the court heard that 2-hour interview that was played for the jury. I also talk about good works of RaDonda Vaught in my sentencing memorandum in her community. And those letters attest to the fact that she's an integral part of that community and gives of her time and is always the person in the area that's willing to help out any of her neighbors. I thought that was significant. I also briefed the issue of her work ethic, her family contribution, that I think are also strong mitigating circumstances. And I also briefed for the court why I believe that RaDonda Vaught poses really no risk of recidivism. I realized that she was charged with misdemeanor perjury in the General Sessions Court for Sumner County. I think the timing of it, Your Honor, is interesting, to say the least. The event allegedly occurred in August of 2020. There was no law enforcement attention made to that filling out of the ATF Form 4473 until a year later. And it wasn't the local Sumner County Sheriff's Office or the Gallatin Police Department. It was the Tennessee Bureau of Investigation. And of course, the Tennessee Bureau of Investigation is the lead agency in this medication error case. So I think they were motivated to pick up the mantle and go up to Sumner County a year later, create this crime, which had not been sought to be vindicated by anybody, not the ATF, not any local law enforcement. And I think I can report to the court as an officer to the court, of the court, that Sumner County is not going to be prosecuting that case. We were in court on May the 4th, and they've indicated that will not be prosecuted. I did want to talk about her eligibility for judicial diversion. And there's sort of a lot of statutory twists that I'm going to try to walk the court through and give the court my understanding of why she is eligible on that impaired elder abuse, the Class C felony. She is indicted under a now repealed statute, Tennessee Code Annotated 71-6-119, impaired elder abuse. It was repealed and replaced with another statutory scheme in 2018. And I know the court is familiar with a statute 39-11-112 that I think contains the answer to this question. 39-11-112 deals with repealed or amended laws. And the relevant portion of 39-11-112 is this. When a penal statute is repealed by a subsequent legislative act, the offense committed while the statute was in full force and effect shall be prosecuted under the statute in effect at the time of the commission of the offense. And that's exactly what happened in this court in the month of March. But here is the language that I think gives the court the authority to grant judicial diversion as to count one. Again, reading from the pertinent portion of 39-11-112. Except as provided under the provisions of 4035-117, in the event the subsequent act provides for a lesser penalty, any punishment imposed shall be in accordance with the subsequent act. So when you take a look at the current plain text of 4035-313, that would be the 2019 replacement, which is found in the 2021 supplement. You sort of need a slide rule to get through this maze, but when you take a look at 4035-313 B1C, and this is the 2021 version, the 2021 pocket part, is not seeking deferral of further proceedings, and then it gives the laundry list of what you cannot be eligible for judicial diversion for. And significantly, 71-6-119 is not in the 2021 or the post-2019 version of 4035-313. It specifically does not mention the old statute that RaDonda Vaught was indicted for by the Davidson County Grand Jury back in 2019. So it would be my insistence based on 39-11-112 and a plain reading of the text of 4035-313, where the old statute is not mentioned, and there are also some ex post facto concerns as well. But the fact that 71-6-119, the old statute, was excluded from diversion eligibility in 2017 is irrelevant to this court's analysis when you apply 39-11-112. And I know of, I think the court is to, my understanding, the court is to use the current 4035-313. And I know of no saving provision that was enacted to, at the time that 71-6-119 was repealed. I know that's a little hard to follow, but when you read 39-11-112 with 4035-313 and apply that language at the end of 39-11-112, where in the event the subsequent act provides for a lesser punishment, a lesser penalty, and that's what we have here. So I believe that she is eligible for judicial diversion using the version that's in effect right now with 4035-313.
4035-313 entirely eliminated from the list of ineligible offenses, vulnerable adult abuse or neglect?
Your Honor, there are replacement statutes that are within B1 4035 313 B1C, but they are not 71 6 119. So I think based on that, she would be eligible for judicial diversion. I would ask the court to seriously consider judicial diversion, and the court is correct. The electroplating factors that you refer to, which are the accused inability to correction, the circumstances of the offense, the accused criminal record. She has no prior criminal record at this point. The accused social history, the accused physical and mental health, the deterrence value to the accused as well as others. Those are the electroplating factors that the court will apply, not the unfortunate comments that she made at a very emotional time right after the conclusion of the trial. I know that the state has brought to the court's attention an aggravating factor.
Let me back up just 1 second, Mr. Strong. Talking about 71, 6, 117, and 119, were those offenses repealed or simply recodified?
Your Honor, I think they were repealed.
They were completely repealed and basically redefined?
That's my understanding. You know, the only other comment that I wanted to make is the state has brought to the court's attention what they characterize as an aggravating factor, and that would be the abuse of a position of private trust. It's not mentioned in the pre-sentence report. There's been no filing that identifies it. I think that to have an abuse of trust, there would need to be a higher mens rea than an accident. And I think in terms of how it relates to count one, as she stood there on the first floor in the PET scan area, at that moment in time, she did not know that she had made that medication error. She only became aware of the medication error sometime later when she returned to the sixth floor, and her colleague, Ethan Gully, handed her that plastic bag and told her, "You didn't give her SED, you gave vecuronium." So, both in terms of a lack of fair notice and factually, I don't think that use of the position of private trust applied in the response case.
Yes, sir. Thank you. I guess I'll endeavor to navigate this diversion issue. I think it's handled pretty well. And the state does disagree with Mr. Strange's interpretation. Yeah, because the act, as originally charged, was recodified. And the recodified statute, 3915-508, which today is gross neglect of a vulnerable adult, is specifically precluded. So at the time in 2017 when this offense occurred, it was specifically precluded under the statute for which Ms. Vaught was indicted. Even as it stands today, she is still statutorily precluded from diversion under the new statute. So the state submits 3911-1112 does not apply because there is no void in the law. There was no lesser penalty. The current law, which was a movement from the health and welfare statutes into the criminal code, just changed sections from the 3915, 3917, and moved them into the criminal code now. Still is a non-divertible B felony. There's no change between the previous, as Ms. Vaught was indicted, statute and this one. So 3911-112 would not apply, and even under today's law, she's still precluded from diversion.
Is the current offense identical to the version that existed at the time of the offense in this case?
I'm not the expert on that, Judge. I would have to look back and compare word for word.
Because if it was simply recodified, it just gets moved into another section, but it's identical. My question is, was it repealed and rewritten, or was it simply recodified from one section of the code to another?
And I Judge, but I can make a late filing for the court if you would like. But I would still submit that if 3911.112 still requires there to be a lesser penalty, you have to punish under the lesser penalty. There is no lesser penalty. It's the same penalty. If you're going to operate under 3911.112 and try to navigate out of diversion and back through again, it's still the same penalty. It's non-convertible and it's a big felony. And I mean, without knowing verbatim, I could read from the indictment and the code as it is in 508.
That's all right, I've got
Okay.
the indictment.
So that, I'll move on beyond that, Your Honor. The state does submit that this is not a deferrable offense. It wasn't in 2017 and it still is not today. The legislation was very clear about specifically carving out vulnerable neglect, gross neglect of a vulnerable adult from diversion.
So you're saying, you're saying that the availability of diversion would not be considered a lesser penalty than under 4035.117. That's not what that means. Is that your position?
I don't think it is. I don't read it to be a lesser penalty. It is. It's a deferral of proceedings. It's not a. The penalty is still there whether it applies or not. It is a function. It's a legislative law.
So a lesser outcome.
It is.
It's a more favorable outcome.
It certainly does, but diversion is a legislative largesse. The legislature decides who gets it, and they specifically said in 2017, and then again after 2018 when it was moved into the criminal code, that vulnerable, gross neglect of a vulnerable adult is non-convertible. And we're going to have a. Can I continue, Your Honor?
Go ahead.
Finish my reply. But I think. I think it tells a lot. We've heard good favorable testimony about Ms. Vaught from her friends and people she's known for a while. But it's very concerning to the state that she did lie on a federal firearms form to get an assault rifle when she was under indictment. It's also very concerning to the state that before the jury even decided her fate, she was saying profanities on the news and accusing me personally, my name came out of her mouth, as a liar. And yet she gave an unsworn allocution today. She chose not to testify at the trial, which is her Fifth Amendment privilege. She didn't want to be subject to cross-examination. Obviously, she didn't want to be subject to cross-examination today as giving an allocution as to why. What lies did the state make in our case in chief around closing arguments? But instead, the statement went to the media. She ran out of this courtroom and went right down the hallway to give her version of the facts to the world. Because she's enjoyed this media darlingship that she has been granted. She has enjoyed being in front of the cameras. She's enjoyed the attention that this has had. Because otherwise, why was she not coming into this courtroom and telling everybody the truth? But she goes out there and says, I lied, and the state lies, and then we're out to get her, and then we don't, not to quote her, but we don't care about nurses and we don't know about health care.
You would agree that the trial of this case was an emotionally charged week, and at the end of that week, an individual who has been through that might say things that they probably shouldn't.
She talked about her professional composure, keeping herself composed. Her allocution, she made it sound like she can hold her emotions together, but she didn't. And she could have walked out of the courtroom and respected the prosecution, respected the sanctity of this court, respected the sanctity of the judicial process and the criminal justice system, but she didn't. She instead tried to say that everybody's lying against me, and I'm a good person, and I'm sweet little RaDonda Vaught, and I didn't testify because I didn't want to be drawn to the mud, but I really maybe didn't want the jury to know that I lied on a federal firearms form and committed perjury just to get an assault rifle. Because she's portrayed herself in the media and with the witnesses here today that she is just as pure as the driven snow. But I don't think that someone that is truly as genuine as she wants the court to believe would, just to get a gun, commit a federal offense, and then go out and curse on TV and blame people who are public servants for doing their job. I think that shows that she is not remorseful, and I think she appreciates the seriousness of this offense by engaging in that game.
Do you disagree with Mr. Stryance that the state of Tennessee has chosen not to pursue that offense? Pursue that charge in Sumner County?
Your Honor, courts, different jurisdictions do things for different reasons. His implication was that we somehow stirred the hornet's nest on that and got it going. But Agent Smith certainly testified that the instant check comes through TBI. That's how TBI got involved. And then when it wound up on Ramona Smith's desk, she's like, I've investigated this woman for a homicide.
And my question is, do you disagree with Mr. Striants that the state of Tennessee has chosen not to proceed with that charge?
I have not received any word from, I can certainly understand a retirement and a subsequent dismissal after a period of time with a misdemeanor. I can understand that. But it still doesn't, I have not received any verified confirmation, neither has the court, that this has actually been disposed of, but it still does not negate the fact that she engaged in that behavior while she was out on bond. And that is considerably concerning for the state. But, Your Honor, I mean, the ultimate question, when does civil medical negligence become criminal? And in this case, it's when it results in a death where a jury decides that she fell below the standard of care and committed so many egregious acts and oversights during that process that somebody died. And we had two members of the healthcare community on the jury who found for that. We had an expert witness who testified about the facts of the case and what nurses are supposed to do. You're supposed to check the medicine. Even their own witness said she would have checked the medicine. I think at the end of the day, it's just check the medicine. Their witness talked about the medication error. It was a volume thing, but she grabbed the right medicine. And I won't go any further with that, but we're talking about, she didn't even look at the medicine. There's no proof of that. That is completely egregious in this situation.
What's the state's recommendation on sentence? That you've just made the same argument you made to the jury, and they agreed with you. They agreed with you. So now tell me what does the state wish the court to do on sentencing?
The state wishes that the court, whatever sentence the court imposes and whatever words the court uses in pronouncing the sentence, must promote respect for the sanctity of life, the sanctity of Charlene Murphey as a patient, the sanctity of her family, and a respect for the judicial system, this court, and the criminal justice system, and the jury's verdict. Whatever that may be is your decision.
I mean, the words that I use are the words that I'm asking you about the sentence. I mean, the sentence is what it is. The length of the sentence, the manner of service, and I understand the state's position on diversion. I understand that position. What's the state's recommendation on the length of sentence and applicability and propriety of an alternative sentence?
We are not seeking, we didn't file an enhancement factor. She does not have a record, so it would be between 3 to 6 years for the C felony and 1 to 2 for the E felony.
You argued an enhancement factor earlier. You're asking the court to enhance the sentence.
Ranging. Enhancement as in within the range.
Okay.
Enhancement factor would be whether.
So you're arguing she's a standard offender.
She is a range 1 standard offender.
Okay.
Not filing enhancement.
And you've argued that at least one enhancement factor is applicable.
Yes, Your Honor.
And so do you have a recommendation or a position on the length of sentence as
The
to?
length between 3 to 6 years.
Mhm.
I think whatever the judge finds is fair between 3 to 6 years for this offense.
So you don't have any position about where?
We do not have a position
Okay.
on how long she is either incarcerated
Okay.
or placed on probation.
And you're not seeking consecutive sentencing?
We are not, Your Honor.
Okay. Are you advocating for any service of time in custody?
We are going to leave that entirely up to the court and your discretion and your
I
wisdom.
mean, I have statutory factors that I have to consider, obviously, but it's always helpful to have, we're in an adversarial proceeding, and I listen to both sides, I listen to arguments, and I weigh those arguments and apply them to the evidence before me. So, but you're saying the state doesn't take a position on probation?
The position that we have is she is non-divertible and the offense needs to go on the registry. Our concern was that she not be able to kill another patient or cause harm to any of the patients in the future. And however that can be accomplished, Your Honor, is all the state is concerned about.
All right.
I'll sit down.
Thank you, General. Did you have a response?
Just very briefly on the eligibility for judicial diversion. Just by the terms of the replacement statutes, I don't think it's just a reconstructed statute because it is a Class B felony in its new iteration. So it's facially not a recodification of what came before. So it would be my insistence that if they wanted to preserve 7160
Ms. Stryance.
Can I be heard just very briefly? on
Yes,
this?
ma'am.
I apologize, Your Honor, I had it pulled up and I lost my place. I'm almost there. Your Honor, the reason that these offenses were moved was to codify them in the criminal code. The 71 section dealt specifically with welfare. And the District Attorney General's Conference made a big push in 2017, 2018, 2019 to have these laws moved over because of the creation of the Vulnerable Adult Protective Investigative Team and these acts to try and promote stopping abuse, neglect, misappropriation, financial exploitation, sexual abuse of vulnerable and elderly adults. So the big movement came to codify these within the criminal code. I disagree with Mr. Stryance. If you look, and this is specific to 4035-313 now, if you look at the statute for 4035-313 back at the time of this offense, which was the charge that in the 71s that she was convicted of, it is specific in that statute that it is precluded, it's prohibited, you cannot get diversion there. If you look at 4035-313 now, it is specific as to the same part of the statute, 3915-508, which says offense of aggravated neglect of elderly or vulnerable adult. Talks about the caregiver commits the offense of aggravated neglect of an elderly or vulnerable adult who commits neglect, results in serious physical harm. That is the same language. Now that still keeps it at a Class C felony. The B felony results in serious bodily injury. That's what bumps it up, that classification. But serious physical harm, that's the same type of harm that the state had to prove in order to find her guilty.
I agree with you that it looks the same.
Yes, Your Honor.
It's kind of similar.
Yes, Your Honor.
And maybe the intent is that we're going to take this crime out of this section and we're going to put it in this section. My question is, and my question before was, has the statute been rewritten? Has the offense been redefined in any way? I'm hearing Mr. Stryance say that at least part of it has been elevated in terms of sentencing. So it's not entirely true, from what, unless you disagree, that it was just picked up and moved from one section to another. It was literally repealed and rewritten. So am I allowed to sit here in this proceeding and see if I can figure out what the intent of the legislature was? I can't do that, can I? I have to look at the statute.
Yes, Your Honor, but I think it speaks volumes to the fact that there was a reason that these charges, these crimes were moved to the criminal code.
But I can't consider that. I have to look at the statute.
Yes, Your Honor, but I think what is important as to that, if Mr. Stryance is saying we need to look as to the intent of 4035-313 as it relates to this time period, as Mr. Jackson said, this particular offense, gross neglect, aggravated neglect, neglect that causes serious physical harm of an elder or of a vulnerable adult, is still precluded even today from obtaining 4035-313. That is the intent of the legislature here, Your Honor, because that type of crime hasn't changed. It's just been moved over to the criminal code and recodified.
But there has to be more than it being just that type of crime. It's more than that. It has to be because this offense, 71-6-119, does not exist anymore.
It does not, Your Honor.
So 71-6-119 no longer appears in 4035-313.
No.
So what gives me the authority to ignore the plain language of 4035-313 and to include a crime that does not exist anymore in the list of crimes for which diversion is no longer an option.
Well, Your Honor, she was prosecuted under the 71-6-119. That was the intent of the legislature. Let's move back in time. Had she been prosecuted under that time when this specific crime was listed in 4035-313, obviously, the legislation has changed. It's been updated to reflect the new laws, the new language that's been codified under the criminal code. But I think what's specific is that the court has to look to what is the intent of the legislature here. The intent of the legislature.
Tell me why. Tell me. My question is, tell me how I can consider that. Tell me how I can look beyond the language of 4035-313 that's applicable today. And if anyone else has any, I'm happy to hear from anyone from the state on this, because I don't know. I'm hearing about, and I understand that the legislature does things and makes decisions and rewrites statutes all the time. Maybe it was an oversight. If it was an oversight, I can't call it an oversight. I've got to look at the language of the statute.
Your Honor, do you have a copy of the 4035 that was effective from July the 1st, 2017 to June the 30th of 2018? If I may.
I do.
Just make sure that we're comparing apples and apples.
You're saying the copy that was effective.
At that time specifically.
Okay, hang on. (4035-313), effective until January 1, 2020. Is that what you have here?
2017.
Okay. And it includes 71-6-119. I see that. And the statute, the section that is applicable until 2020,
Yes, Your Honor.
also includes 71-6-117.
Yes, Your Honor.
Okay.
And just to let the court know.
I mean, I understand that at one point it was included.
Yes, Your
But
Honor.
my question is, now it's not included.
But
So,
specifically, the welfare code section 71-6-119, is not included. But because it has been converted over to the criminal code, and just to let the court know, if you look in the code now, if you look at 4035-313, it's still the language that talks about a qualified defendant. But if you look to section C, Your Honor, the place where 3915-502, which was financial exploitation, that is the same code section that is listed under the 2017-2018 for financial exploitation, because it had already been transferred over into the criminal code. Exactly where 71-6-117 and 119 is listed in that statute now places 3915-508 and 3915-511. And 3915-508 is the aggravated neglect of an adult. So I think there's a problem here with the way it's written. I certainly agree with the court here. But
I mean, I can't correct that, can I?
no, Your Honor, but I think looking at the intent here of what the legislature did by recodifying into the criminal code, putting the exact same type of charge, gross neglect, aggravated neglect of a vulnerable or elder adult, within that subsection in 4035-313, because the law has just been modified or updated to be in the criminal code. I don't know that the legislature would have added 71-6-117 or 71-6-119 just for the simple fact that that's not the code section in the criminal courts or the criminal laws that we proceed under anymore.
It is if you committed your offense when that was the statute in effect.
Yes, Your Honor.
As we did here.
Yes, Your Honor, but I think the court can take consideration of the fact that it was enumerated in 4035-313 at the time. And that's the time that she committed the offense. And that should be the laws that she is held under as her sentencing. But I think the legislature would not have put in this particular statute in the 2021-2022 books, just because that's not under, we don't act under the welfare law anymore. It's specific to the criminal code. So I don't think you can just negate the fact that the statute has changed without looking at the language and the meaning of of what's behind this. The intent of the legislature here is you cannot abuse an elder or vulnerable adult. You cannot neglect an elder or a vulnerable adult. You cannot financially exploit. If you do, you are not eligible for 4035.
So just to be clear, your argument as to the reason that 3911-112 that deals with repealed or amended laws, the reason that that would not provide relief in this instance with respect to diversion is because the offense is similar and the legislative intent was that it just be moved to a different section.
That is exactly what happened, Your Honor, and that was the big push by the District Attorney General's conference to codify these offenses within the criminal code, and the court can see that based upon the 39-15-502, which is within the 4035-313 statute that had already been moved over at the time in 2017. Financial exploitation was the first crime to be moved over to the criminal code.
Okay. All right. All right, I'm going to take a recess. I'm going to review the evidence that's been presented, review my notes from the trial, review the case law and the legal arguments that have been presented, and then we'll come back and announce a decision. That decision would probably, I'm going to estimate that it's going to be probably 1 o'clock before that happens. So if you want to plan to be back here by then, I'll have a decision.
All rise. Court's in recess. Ladies and gentlemen, listen up. You got a pass. That'll be the only way you get back in at 1 o'clock. If you don't have a pass, you will not come back in. All right.
I was reading Facebook posts. She acts like we don't understand. Yes, that's RaDonda All you hear is just Google the sugar-free chocolate. They don't make it anymore. The reviews are like, I thought it was a joke, so I ordered them, paid the whole bag, and I haven't looked at them, they're in state and stuff like that. Wonderful. It's like a novel. It's a good novel. Big pleasure. So I could do my lady riding.
He's got his tiny weight pants and
ain't doing it.
out there?
Yeah.
Gotta be like 90 something degrees out there.
It seems like everybody's in the shade around the square. They went hit hard.
I'm sure lots of those people thought they were going to a 90-minute thing. You know, it's like, I'll be back in the house later kind of stuff, right?
Okay. It's pretty much just. Oh, yeah. Right.
Yeah, I mean,
What's up in Shrine?
That's concerning to me because I just have a class. I know. Like she's almost 15 now. I was like, yeah, like I was like, everything would be yeah, that's serious. If I had a house, I'd be like, bring them on back. Don't buy a house just so I can.
just a minute, I apologize. Okay. So this case came today to be heard for the sentencing of the defendant, RaDonda Vaught, on her conviction following a jury trial of impaired adult abuse, a Class C felony, in violation of TCA 71-6-119, and criminally negligent homicide, a Class E felony, in violation of TCA 39-13-212. In determining the appropriate sentence for this offense, this court has considered the evidence presented at trial and the sentencing proceeding today, the pre-sentence investigation report and all corrections and additions to that report, the sentencing considerations outlined in TCA 4035-103, the nature and characteristics of the criminal conduct involved, the evidence and information offered on enhancing and mitigating factors, the defendant's statement here at sentencing, and the defendant's potential for rehabilitation or treatment. From all of this, the court finds as follows. The parties have agreed that the defendant is a Range 1 standard offender pursuant to Tennessee Code Annotated 4035-105, subject to a sentence range of 3 to 6 years at 30% release eligibility for a Class C felony, which is the impaired adult abuse conviction, and 1 to 2 years at 30% release eligibility for a Class E felony, which is the criminally negligent homicide conviction. By statute, this court is required to impose a sentence within those ranges. In making that determination, the court is required to consider, but is not bound by, 2 guidelines. Number 1, the minimum sentence within the range of punishment is the sentence that should be imposed, because the General Assembly set the minimum length of sentence for each felony class to reflect the relative seriousness of each criminal offense in the felony classifications. And 2, the sentence length within the range should be adjusted as appropriate by the presence or absence of mitigating and enhancement factors, as set out in Tennessee Code Annotated 4035-113 and 114. So with those considerations in mind, the court has considered evidence supporting statutory enhancement and mitigating factors. The state proposes that enhancement factor number 14, that the defendant abused a position of public or private trust, is applicable. Ordinarily, this circumstance applies in situations in which a defendant has specific or unique access that permits the commission of an offense. Examples of those types of cases are sexual offenses committed by caretakers, which was a situation in State versus Kissinger, which was the case cited by the state at argument. Other situations include where a defendant has access to internal records or accounts and uses that access to commit financial offenses or forgeries. State versus Franklin, 919 Southwest 2nd, 362, and State versus Finch, 465 Southwest 3rd, 584, are examples of those types of situations. Application in those types of contexts and the use of the term abuse in the enhancement factor itself suggests to the court that a higher level of culpability than simple criminal negligence is required to meet the standard, and thus does not find that this particular enhancement factor applicable to count 2, criminally negligent homicide. As to count 1, impaired adult neglect, the court also declines to apply the factor because the caregiver or trust relationship is an essential element of the offense and may not be duplicated through enhancement. The court has also considered certain mitigating factors. and has heard proof on those today. The defense first proposes application of factor number 11, that the defendant, although guilty of a crime, committed the offense under such unusual circumstances that it is unlikely that a sustained intent to violate the law motivated the criminal conduct. The court agrees that this factor is applicable here. This offense occurred in a medical setting. It was not motivated by any intent to violate the law, but through oversight and gross negligence and neglect, as the jury concluded. The defendant also accepted responsibility immediately. She made every effort in the moment that she recognized her error to remedy the situation, to notify the appropriate individuals, and then later to ensure that all of the facts and details were brought to light. The court has also heard proof today on the catch-all enhancement factor, factor number 13, and finds several circumstances applicable under that provision. First, the court observes that the defendant's acceptance of responsibility immediately and her remorse throughout this proceeding support application of factor 13. Testimony and letters from friends and colleagues attesting to her work ethic, her character, her kindness and generosity also support application of this factor. The court has also considered the fact that Ms. Vaught will never again be in a position to repeat this fatal error. She has been stripped of her nursing license and has started a new livelihood outside of the healthcare profession. All of these factors and considerations support the application of the catch-all mitigating circumstance number 13. The court has also considered the Murphey family and their terrible loss. Nothing that happens here today can reverse that loss or ease that pain. And I have seen from my own experience, not only on the bench, but in my previous practice experience, that sometimes it seems that the attention in criminal cases tends to shift as the case goes on from the victim to the offender. In this particular proceeding, the attention is obviously on Ms. Vaught because I have to determine the appropriate punishment and result and outcome from the jury verdict. But I want to assure the Murphey family that this court is deeply mindful and sorry for their loss. It is my hope that changes in the practices and protocols in the medical setting that have arisen since this event may at least be some positive aspect that has arisen, and that going forward, I hope that it prevents this type of situation from happening again. I recognize, however, that that will never be enough to heal your wounds. Considering the applicable mitigating factors here and the absence of any applicable enhancement factors, the court will, as to count 1, impaired adult abuse, set the sentence at 3 years. As to count 2, the court sets the sentence at 2 years for criminally negligent homicide. This is the maximum amount of time allowable by law that this court would be allowed to impose for criminally negligent homicide. And the court does so in recognition of the terrible loss sustained by the Murphey family. These terms will run concurrently, there being no evidentiary or statutory basis in this case for consecutive sentencing. So the sentence in this case will be an effective 3-year sentence. The court has also considered whether to grant or deny alternative sentencing. The law requires that the court consider alternative sentencing regardless of whether it's requested. And by statute, the court has to consider a number of specific elements. The court has done that. The court finds that the defendant's potential for rehabilitation is great. The court further finds that the defendant will likely abide by the terms of probation based upon the testimony before the court, based upon the information in the pre-sentence report, which places her chance of recidivism as low and the need for intensive supervision as low. The court finds that the defendant is not likely to reoffend. As I stated earlier, she's no longer in a medical setting. She no longer possesses a nursing license. The court also does not find that a probationary sentence will unduly depreciate the seriousness of the offense. The proof at trial and the proof here at this sentencing demonstrated, I think, that Ms. Vaught is well aware of the seriousness of the offense. She immediately and consistently accepted responsibility for her actions, and she credibly expressed remorse in this court. The more challenging issue for the court has been the question of judicial diversion. Specifically, whether the defendant is even eligible for diversion with respect to count 1. The defendant in this case was charged and convicted for a violation of Tennessee Code Annotated 71-6-119. The offense was committed in 2017. On May 24th, 2019, Governor Bill Lee signed into law Chapter 2019 Public Acts, Chapter 474. That act was entitled the Elderly and Vulnerable Adult Protection Act of 2019. With respect to Title 71, the Act amended Tennessee Code Annotated 71-6-124, which addresses a circumstance that's unrelated to this case. But notably, the Act expressly, and I quote, deleted in their entireties sections 71-6-117 and 71-6-119, the provision under which the defendant was convicted here. Those crimes in 71-6-117 and 71-6-119 no longer exist. They were replaced by new offenses that are similar, but they are not the same. Tennessee Code 71-6-119 is no longer excluded from diversion under Tennessee Code Annotated 40-35-313. Perhaps that it was the intention of the legislature that it still be excluded, but it was not by the plain language of the statute. The legislature was surely aware of TCA 40-71-6-119 when it amended 40-35-313 and when it adopted the Elderly and Vulnerable Adult Protection Act of 2019, and it could have kept that code section in the list, among the list of excludable offenses in 40-35-313, but it did not. And this court does not have the authority to look behind the plain language of the statute and try to glean an intent that is not expressly stated in the statute. The court thus concludes that an offense under Tennessee Code 716119 is no longer disqualifying for purposes of diversion. Again, whether that was an oversight or mistake or whatever the intention of the legislature was, the legislature speaks through its acts, and this court can't second guess or go behind the plain language. The defendant has requested diversion for both offenses in this case, and the court has considered the factors set out in State versus Electroplating, 990 Southwest 2nd 211. The factors that the court are required to consider in determining whether to grant a judicial diversion are the accused amenability to correction, the circumstances of the offense, the accused criminal record, the accused social history, the accused physical and mental health, the deterrence value to the accused as well as others, and whether judicial diversion will serve the interests of the public as well as the accused. With respect to the circumstances of the offense, the court finds that there was no sustained intent to violate the law, and that the defendant is highly amenable to correction. She has no criminal record. She's been removed from the healthcare setting. She will never practice nursing again. This situation will never be repeated by Ms. Vaught. The court is particularly concerned about the deterrent, or has looked most carefully at the deterrence value to the accused as well as others, and whether judicial diversion will serve the interests of the public as well as the accused. The court does not find that a denial of diversion will in any way undermine any deterrence. In fact, there is no deterrence value by denying diversion in this case. This was a terrible, terrible mistake. And there have been consequences to the defendant. Serious personal consequences, financial consequences, professional consequences, and now public consequences in a criminal setting. Court also does not find that judicial diversion would in any way undermine public interest. Again, this is not a situation that involved any sustained intent, and changes, modifications, responses that have occurred as a result will certainly serve a greater value in preventing a reoccurrence than by denial of diversion in this case. The court therefore finds that judicial diversion is appropriate and will enter an order today placing the defendant on supervised probation for an effective period of 3 years, and will defer entry of judgment pending successful completion of that probation. And that will be the order of the court.
All rise. Court stands adjourned until Wednesday morning at 9 a.m.
I have the original.
Do it right here. They're still.
We have it left. Wait, go back.